Hello, and thank you for listening to the K&L Gates Working Wise podcast series. My name is Erinn Rigney, and I am a Labor, Employment, and Workplace Safety Associate in the firm's Chicago, Illinois office. My practice focuses on helping clients across various industries with a wide range of employment and labor matters. In this segment of Working Wise, I will discuss a recent Seventh Circuit Court decision that opens the door for job applicants to assert claims of disparate impact under the Age Discrimination in Employment Act. The Age Discrimination in Employment Act, or ADEA, protects certain applicants and employees 40 years of age and older from discrimination on the basis of age in hiring, promotion, discharge, compensation, or terms, conditions, or privileges of employment. The ADEA applies to private employers with 20 or more employees and is enforced by the Equal Employment Opportunity Commission, or EEOC. Passed in 1967, the ADEA was an effort to address congressional findings that the population of older workers had been denied employment opportunities due to age-based stereotypes. Originally, the ADEA only protected workers between the ages of 40 and 70. However, the upper age limit was removed following a 1986 amendment. In the past few decades, many individuals actively seek employment past the age of 40 and remain in the workforce well beyond the typical retirement age, requiring that employers be cognizant of the effect certain policies and procedures may have on this class of workers. Over the years, courts have interpreted the ADEA as prohibiting both disparate treatment claims and disparate impact claims. Disparate treatment occurs when an individual is subjected to less favorable treatment by an employer because of her age. A plaintiff alleging disparate treatment on the basis of age must establish that the employer intended to discriminate. Disparate impact occurs when an individual claims that the employer's facially neutral policy or practice had a disproportionately negative effect on an individual because of his or her age. Employers can avoid liability if the policy or practice is based on a reasonable factor other than age, of which the employer holds the burden of persuasion. Prior to a recent Seventh Circuit case, Kleber v. CareFusion Corporation, job applicants were ineligible to bring disparate impact claims under the ADEA. This presentation will discuss the Seventh Circuit case, its impact on employers, and a few best practices. The plaintiff in the Kleber case, Dale Kleber, was an attorney with an extensive legal background, including work at a private law firm and stints as a general counsel at various companies. After his employment ended in 2011, Kleber began searching for a new job, and in 2014, at the age of 58, applied for a senior counsel position at CareFusion Corporation. The job posting that Kleber responded to called for, among other things, a business person's lawyer with an ability to assume complex projects. In addition to these qualifications, the posting also noted that applicants must have 3 to 7, but no more than 7 years of relevant legal experience. Despite having more than 7 years of relevant legal experience, Kleber applied and was rejected for the position, which was ultimately filled with a 29-year-old applicant. Following his rejection, Kleber filed a charge of discrimination with the EEOC, alleging that the 7-year experience cap subjected him to age discrimination in violation of the ADEA. CareFusion responded to Kleber's charge, stating that this maximum experience level was objectively based out of concern that an individual with more than 7 years of experience would not be satisfied with the less complex duties of the position. After receiving a right to sue letter in December of 2014, Kleber filed a lawsuit in the Northern District of Illinois, alleging claims of both disparate treatment and disparate impact. Specifically, Kleber alleged that this experience cap was based on unfounded stereotypes and caused a disparate impact on older workers. The district court dismissed the disparate impact claim, relying on a 1994 Seventh Circuit decision, which held that the ADEA's disparate impact provision did not extend to job applicants who were not already employees of a defendant employer. After Kleber dismissed his disparate treatment claim, the district court issued final judgment in the case, and Kleber timely appealed that decision. On appeal, the Seventh Circuit addressed whether the ADEA's provision on disparate impact protects only current employees or whether it protects both current employees and external job applicants. The court held that the disparate impact provision protects both external applicants and current employees, opining that this result was the better reading of the statutory text, as well as more consistent with the underlying purpose of the ADEA. Within the court's extensive analysis, it noted that the ADEA extends protection to any individual and not just employees, bringing all job applicants within the ambit of that section of the statute. The court also analyzed 50 years of interpretations of both the ADEA as well as Title VII of the Civil Rights Act of 1964, a statute that allows both employees and job applicants to bring disparate impact claims. Furthermore, the court looked to the fundamental purpose behind the ADEA, which focused on addressing the unequal playing field for older workers. Overall, the court noted that it had not been presented with and could not imagine on its own a plausible policy reason allowing disparate impact claims by current employees while excluding external job applicants. By allowing Kleber's claim to proceed, the court focused on the practical implications of CareFusion's argument that the ADEA only extends to internal applicants. The court determined that to allow such a result would be arbitrary and even baffling, especially under a statute with the purpose of prohibiting age discrimination in employment. Though its holding allows job applicants to proceed under a disparate impact theory, the Seventh Circuit did not address CareFusion's potential affirmative defenses, specifically if the experience cap was based on reasonable factors other than age. By remanding it to the district court, the Seventh Circuit affords CareFusion the opportunity to defend its experience cap at the trial court level, where it potentially will have the burden to justify the use of the maximum experience qualification. In reversing the district court, the Seventh Circuit became the first federal appellate court and the second federal court to extend the disparate impact theory of recovery under the ADEA to all job applicants. This holding directly conflicts with the decision by the 11th Circuit in 2016, which held that only current or former employees could bring a disparate impact claim under the ADEA. The Kleber decision creates a circuit split between the 7th and 11th Circuits, which could eventually tee this issue up for future Supreme Court review. In the meantime, employers may experience an uptick in claims alleging that recruiting and hiring practices have a disparate impact on older job applicants. Though this ruling only directly affects employers with employees in Illinois, Indiana, and Wisconsin, all private employers subject to the ADEA should be cognizant of the effect their recruiting and hiring practices have on older workers, both in the form of intentional discrimination and disparate impact. Specifically, covered employers should review current recruiting and hiring practices for potential negative impact on job seekers, evaluate hiring materials for facially neutral criteria that may disparately impact older applicants, draft job postings with age-neutral language, avoiding experience caps and other limiting qualifications, and train recruiters and human resources professionals to avoid using such criteria during the candidate screening process. We hope you enjoyed this episode of K&L Gates Working Wise podcast series. More episodes in our series can be found at klgateshub.com, and you can learn more about our labor, employment, and workplace safety practice on our main website, klgates.com. Thank you for listening and have a great day.